All right, welcome back to the Law&Crime Network. My name is Bob Bianchi. I'll be with you at 3 o'clock, one more hour to go to break down this fascinating case of Scott Nelson. Death penalty phase right now, and the prosecution put on compelling victim impact testimony, especially of the daughter and the husband. Wow, man, I've seen a lot of victim impact testimony. It rivaled the Chris Watts, if you remember that case in my mind, in terms of its impact. But they also, the prosecution put on Carol Terrick. Carol Terrick was the bank teller that led to him ultimately being convicted when he went in there with that briefcase and said it was a bomb and robbed from them, and wound up in the federal prison that we've been talking so much about, this whole thing about his jail experience and whether or not that's going to be considered an aggravating factor by the jurors or a mitigating factor as to that this is why the guy is the way he is. So let's listen to Ms. Terrick. Okay, Carol Terrick telling us about what it was like in a previous commission of a crime, a bank robbery. Now, I've got the privilege and honor, ladies and gentlemen, to introduce on her maiden voyage at the Law&Crime Network, Sara Becker. She's out of Georgia. Very impressive credentials, of course, because she's a guest at the Law&Crime Network. Sarah's been working for 15 years as an experienced complex criminal litigator, handling many cases in state and federal court. She works for the Georgia Innocence Project. That's a really laudable project and has done a lot of amazing work for people wrongly convicted of crimes. She's a lecturer at Georgia State University and a national legal analyst. Welcome to the show, Sara.
Hi, happy to be here, Bob.
Okay, awesome. So, the prosecution's kind of got a lot in its toolbox here with many, many aggravating factors. You have this powerful victim impact testimony to show the jurors, as a death penalty litigator myself, the effects that this has had, on the family. This beautiful woman, Judge Ashley Wilcott was just on, another one of your Georgia colleagues out there, who was indicating that she's the perfect victim in a certain sense. She did nothing to bring this on to herself. And then the prosecution's also putting on other witnesses to talk about a career criminal, a violent career criminal, and all the lives he affected, including that teller there. And I understand that people are making an argument that he had a bad life and he had maybe he has a mental disease or defect, but the brother who also testified in his defense, well, he came from that same environment too, and he doesn't go out killing people and bank robbing as well. So far, Sara, what are you thinking about how the case is going in for the prosecutor versus the defense?
I think that the prosecutor is certainly in the stronger position at this point. As you pointed out, Bob, these factors, whether they're aggravating or mitigating, isn't a black and white issue. You see that clearly in this case, that some of the testimony that comes in, one person may look at it and say, well, that's a reason to kind of mitigate the acts that this man took, while somebody else may look at it and say, are you kidding me? This makes him more dangerous. This is something that's going to make it harder for him to control impulses. So at this point, I think that the way that those factors are determined is going to depend largely on how the jurors receive them and their life experiences. Yeah,
and that's a great point. But, I got to say, as a prosecutor who's actually handled death penalty litigation, boy, I like this case as a prosecutor. I like what I got. I like the witnesses. You never know what can happen. And to your point, we actually had a juror that got removed because, as you know, to death qualify a juror, they have to say that they would impose the death penalty if the aggravating factors were proven beyond a reasonable doubt, and they felt that was the right decision. And that juror, after the guilt phase, was overheard saying by another juror that this isn't a death penalty case, and that juror was removed, an alternate was put in. But it goes to the point, in that juror's life's experience, like you put it, Sara, he didn't feel that he heard anything that would have justified the death penalty, which is kind of shocking.
It is. As a defense attorney, this would be one of the cases that I would certainly struggle with. You see a man who doesn't seem to express a lot of remorse over the actions that he's taken. He seems almost numb sometimes through his testimony, or the victim is an afterthought. I mean, I believe, didn't he refer to her at one point as collateral damage?
Yeah. No, you're right.
That to me, as a defense attorney, that kind of demeanor would be incredibly difficult to overcome in the eyes of the jurors who have this man's life in their hands.
Right. The other day, I was talking to Paige Pate about this, a difficulty when you're a defense lawyer defending a guy like this. And it's not for the fair of heart, that is for sure. Anyway, so that bank teller gets great information out with respect to this case, but the assistant manager that she referred to, he also testified for the prosecution. Let's take a look. All right, Sara Becker. So we have both of these witnesses now. That completed the testimony with regard to that bank robbery. I'm thinking through my mind. The prosecutor's bringing out that well before the murder case, this guy was planning. He's methodical. It's about money, and that's what it was about with this case. Don't be fooled by this. It had something to do with the probation officer. It's about robbery. That's what this was, plain and simple. And he doesn't care who he's frightening. He has no concern. He's got two people that are at their wits' end, and this is just a genuinely bad human being. That's where the prosecutor wants to go with that, no?
Correct. Absolutely, Bob. And again, just kind of the deadpan. I think that these witnesses in combination with the testimony from the defendant himself, where there really doesn't seem to be any engagement, any acknowledgement that this victim, there was value with this victim, right? It's just an incredibly, incredibly difficult situation for the defense at this point.
Sara, I want to ask you something I kind of alluded to before. In my defense practice, which now is like 50% prosecutor, 50% defense in my career at this stage, I've represented a lot of people, tried a lot of murder cases as a defense lawyer. And you know what? I found that I've liked most of my clients, and I had no difficulty fighting the fight for them, whether it's to get a reasonable plea offer or if they want to have their day in court trying that case. I think I would find it very, very difficult sitting down with this guy, if for nothing else than his cavalier, contemptuous way that he refers to the victim as collateral damage and a lack of remorse would make it very difficult for me to do my job for him. I'm just being honest.
Certainly, and that's something that, as former public defender, I've struggled with before. When you don't have the opportunity to kind of choose your cases to some degree. What I believe the defense attorneys probably really have to do is dig down and associate themselves with their faith in the process and really kind of defend the person in the abstract as much as you can when you have to try to personalize them to the jury. But certainly that's a struggle and a true gift to be able to disassociate yourself from maybe a personal sense of dislike or animosity that you may have.
No, and the fact is, that's what we do as defense lawyers. We understand, and I understood that as a prosecutor, the value, regardless of who the defendant is. I used to like when I had really good defense attorneys, because then I know the system of justice plays out better, irrespective of who that defendant sitting in that chair is. Let me ask you the last question. We talked about this again last week with a couple of the lawyers. I always used to say public defenders, of which you were one, do God's work. And what I mean by that is it's especially difficult, in my opinion, the job public defenders do, because the clients typically don't have regard or respect for the public defenders, although I have tried cases against some amazingly talented public defenders. Certainly,
and I think as in my prior role as a public defender, you kind of have to earn that credit with your client. And oftentimes I was able to. And in the circumstances where you aren't able to, you just have to push through. It can make putting up a viable defense more difficult, though, because then sometimes, you're working less as a team with your client and somewhat in opposition and trying to figure out how you can best advocate for their rights and put them in the best position when maybe they disagree with you strongly in a lot of places.
Mm-hmm. All right. Great, Sara. I really appreciate it. Sara, I don't know how I'm speculating here, okay? I feel the defense, something went wrong with this testimony, and she's struggling to find a way on redirect to try to square it away. Now, we know a couple of things about what the prosecutor did on cross, and you know, because you're an experienced litigator, that sometimes redirecting could even be the worst thing you could do because you're not scoring any points. So this guy, who is a defense expert, first of all, he never interviewed the defendant. And you know that that's a big thing. You didn't look at necessarily all the records, but he did indicate that he had 68 infractions over 20 years, that he was for insolence, making threats, assaultive behavior. He refused work programs. And then the prosecution got out the part where she's trying to redirect right now, the defense lawyer, saying that he'd have a psych assessment every weekly. It was very basic, but every 30 days there was a more formal one. And I think the prosecution's bringing it out to say, one, he elected to be there, and two, no one noted any serious psychological problems but for some stuff that happened years and years ago. I don't think that that's a good witness for the defense. I think it imploded. What do you think?
Yeah, I agree, Bob. And I think you can see it even in the minute details. You referenced some of them. I took note when he was on cross-examination, and there was a comment about 90% of the time, and he said, well, actually 95, right? So he's a defense witness, but it seems like he's kind of, even his qualifications are helpful to the prosecution. And in this case, when the defense is trying to redirect and bring out the fact that he had suicide attempts and personal harm attempts, and he says, well, yeah, that was a really long time ago. So I don't think this witness went at all the way they would have liked it to do, with the goal of humanizing Mr. Nelson to the jury.
Right, and what I found interesting about that as well is that you're asking the questions. It sounded to me like she was hesitating, and then she was getting not the good answers. Like, it was nothing that was even recent. But the only point that she, I guess, scored in my mind, and again, I think she probably would have been better off sitting down and not redirecting, is that there's less freedom. But again, the prosecution did a great job saying that was his choice to do that. So I don't see how that witness at all scored any points for the defense in the case. And I'm wondering, do you think it was a lack of witness preparation? Because this is something that you would anticipate as a defense lawyer. Don't you do this yourself, Sarah? You ask, what would the prosecutor ask on cross-examination? And this stuff seems pretty basic.
Yeah, absolutely. I hate to try to second guess somebody else's trial work because I'm not there and I'm not in the moment. And it can be more difficult when you're working with a different client, but certainly you would expect her to have kind of known the answers to those questions in advance. And as you said, just at the very least, not ask them.
Yeah, and there are so many factors that are at play, to be fair. You don't know whether or not the defendant insisted on the person going on there, or you didn't, it's hard to say. But sometimes I've, as a prosecutor, eviscerated some witnesses, especially expert witnesses, failure to review all the records, failure to interview the defendant, and then basic common sense things that I don't think the defense had anticipated. But who knows? We will find out what the jury ultimately says about this case after the holiday break. We're going to have more of Sara with us and more of the breakdown of the Scott Nelson trial on the other end of the break. Stay with us. Sara, in so many dimensions and on so many levels, it's chilling and it's not good for him. I don't buy that this jury's not going to come back. I'd be upset as a prosecutor if this jury did not come back in the death penalty within an hour. I'd put a time limit on it, but let's break it down. He's talking so descriptively about how he went about preying upon this victim. Plenty of deliberation. No, I didn't have the zip ties and so on and so forth because I don't want to look like Rambo going down the street. That's a very logical thing for a bad guy to say. And that he was doing reconnaissance on her. And, hey, why break into the place? Just ring the doorbell. She's the one who let me in. Almost like she let me in. It's her bad. And he made the decision that night. And there the night before, and there he is waiting, lying in wait to execute his plan. This is not a person who did not have an opportunity to deliberate and change their mind. He was going to go there to commit an execution and rob this woman. And the flippant manner with even his body language as he's sitting there with his hand and then telling the prosecutor how to go about doing her job. I mean, it's just bad in every dimension.
Absolutely. I think when you said chilling before, you nailed it. When he said, I didn't have to. She opened the door and let me in. It could have been anyone, right? Anyone could do it. Those kind of things are going to stick with the jury, I think. And they are, they're going to alienate the jury from this man. He is in a position, and his defense team are in a position where they really should be grasping at any connection that they can make with this jury to try to make it seem a better option to them to keep this man alive than return a death sentence. And certainly that kind of testimony didn't get them there.
I have one observation before we go to the next clip. When I was prosecuting a death penalty case one time, they put a aging out expert, they called it, on the witness stand, who basically talked about how torturous prison is. And maybe part of the defense strategy here is to talk about how bad, how much he hated it, how he put himself into the shoes so that he wouldn't have to interact with other prisoners. As an argument to say, you want to really torture the guy? Keep him in jail for the rest of his life as opposed to give him the easy out by execution. I would not be shocked that that is an argument that the defense comes up with. But Sara, before we get to that, I'm sorry, I just had to throw that out there. It was at the top of my mind. Let's listen to a little bit more cross of Mr. Nelson. Okay, so Sarah, let's go through this a little bit. First of all, that woman is like such an objectification of the victim in the case, and says that she never did anything to me. But the prosecutor's trying to bring out, yet you had her, duct tape tied up and all sorts of bad things to leave her someplace. Yes, I have one critique for and I say this all the time when I train people in the trial practice. This axiom that don't ask an open-ended question like why. Why did you want to murder or something that maybe you should have thought about asking there real quick, 15 seconds or less? Would you have asked the why question?
No, I wouldn't have, because that was the most humanizing testimony I think that he gave. Now, granted, it still wasn't, I think, enough, but where he said, I never wanted to kill her. Right. Was it credible? Maybe not, but it was better than what he'd said before. All
right, Sara Becker, thank you so much. Everybody here at the Law&Crime Network, stick with us. George Spencer in his debut coming up next with more of this analysis of this case. Happy 4th of July.